This is part 54 as far as our lecture series is concerned, and in this part we shall have reference to chapter 24 of the Criminal Procedure Code, which starts right from section 300 up to section 327 of the Criminal Procedure Code. During course of our discussion as far as the Criminal Procedure Code is concerned, we had reference to some of the sections during the course of time. But some of the provisions with which you are not dealt so far, out of which one is section 300, which deals with person once convicted or acquitted cannot be tried for the same offense. And this is the principle which is based on the maxim autre fois acquit or autre fois convict. This can be compared with that of the principle with which everybody deals when he deals with the provisions of the Civil Procedure Code as far as res judicata is concerned. And then if you refresh your memory as far as the constitutional law is concerned, you have already dealt with the doctrine of double jeopardy as far as Article 20 of the Constitution of India is concerned. And there I had told you that in order to master the provisions of the Criminal Procedure Code, you must remember Article 20, you must refresh Article 21 and Article 22 of the Constitution of India. So this is one point, namely at the time of understanding section 300 of the Criminal Procedure Code, you must remember the doctrine of double jeopardy with which you are dealt. Now what it says, subclause 1 of section 300 says, a person who has once been tried by a court of competent jurisdiction for an offence and convicted or acquitted of such offence shall, while such conviction or acquittal remains in force, not to be liable to be tried again for the same offence, nor on the same facts for any other offence for which a different charge from one made against him might have been made under subsection 1 of section 221, or for which he might have been convicted under subsection 2 thereof. So this is the time, in order to understand this section, refresh your memory regarding charge in the alternative with which you are dealt by taking into consideration subclause 1 and subclause 2 of section 221 when we dealt with charge right from section 211 up to section 224 of the Criminal Procedure Code. With this now, subclause 2 says, a person acquitted or convicted of any offence may be afterwards tried with the consent of the state government for any distinct offence for which a separate charge might have been made against him at the formal trial under subsection 1 of section 220. When we dealt with joinder of charges, we dealt with proviso to section 218, section 219, enumeration as far as section 220 is concerned, 221 and section 223 which deals with joinder of charges. Now subclause 2 of section 300 has got reference to subclause 1 of section 220. Subclause 3 says, a person convicted of any offence constituted by any act causing consequences of which, together with such act, constituted a different offence from that of which he was convicted, may be afterwards tried for such last mentioned offence if the consequences had not happened or were not known to the court to have happened at the time when he was convicted. With this, subclause 4 says, a person acquitted or convicted any offence constituted by any acts may, notwithstanding such acquittal or conviction, be subsequently charged with and tried for any other offence constituted by the same acts which he may have committed, if the court by which he was first tried was not competent to try the offence with which he is subsequently charged. With this, subclause 5, which says, a person discharged under section 258 shall not be tried again for the same offence except with the consent of the court by which he was discharged, or of any other court to which the first mentioned court is subordinate. And the last clause to this section, namely subclause 6, says nothing in this section shall affect the provisions of section 26 of the General Clauses Act of 1897 or of section 188 of this code. And the explanation to the section says the dismissal of a complaint or discharge of the accused is not an acquittal for the purposes of this section. So this is regarding section 300 of the Criminal Procedure Code, which deals with that person once convicted or acquitted cannot be tried for the same offense, along with the, as I have told you, 6 clauses which are required to be taken into consideration for the purpose of understanding the principle and rest of the provisions with which we have to deal. With this now, section 305 of the same chapter deals with procedure when corporation or registered society is an accused. And subclause 1 says, in this section, corporation means an incorporated company or other body corporate and includes a society registered under the Societies Registration Act of 1860. Subclause 2 says, where a corporation is the accused person or one of the accused person in an inquiry or trial, it may appoint a representative for the purposes of inquiry or trial, and such appointment need not be under the seal of the corporation. Subclause 3 says, where a representative of a corporation appears, any requirement of this code that anything shall be done in the presence of the accused or shall be read or stated or explained to the accused shall be construed as required, that thing shall be done in the presence of the representative or read or stated or explained to the representative, and any requirement that the accused shall be examined shall be construed as a requirement that the representative shall be examined. Subclause 4 says, where a representative of a corporation does not appear, any such requirement as is referred to in subsection 3 shall not apply. Subclause 5 says, where a statement in writing purporting to be signed by managing director of the corporation or by any person by whatever name called, having or being one of the persons having the management of the affairs of the corporation, to the effect that the person named in the statement has been appointed as a representative of the corporation for the purposes of this section, is filed, the court shall, unless the contrary is proved, presume that such person has been so appointed. Subclause 6 says, if the question arises as to whether any person appearing as a representative of a corporation is in an inquiry or trial before a court is or is not such representative, the question shall be determined by the court accordingly. So this is with respect to procedure to be followed when corporation or registered society is an accused person. With this now, the next topic that we are going to take into consideration as far as this chapter, right from section 300 up to section 327 of the Criminal Procedure Code is concerned, is try to understand what do you mean by tender of pardon. And in order to understand tender of pardon, we are going to deal with 3 sections, namely section 306, section 307 and section 308 as far as this chapter is concerned. Now, when we shall be dealing with tender of pardon, we will try to understand that first of all, who can tender pardon? Who has got power to tender pardon? That is one aspect. At which stage pardon can be tendered, which is of course always a conditional tender of pardon, which may be withdrawn or which may becomes an absolute, yes, with which we shall be dealing. And then the procedure that is required to be followed, and then the offences for which this provision regarding tender of pardon is made applicable is made very clear as far as this chapter is concerned, with which we shall be dealing during course of time. If you read section 306, which says tender of pardon to accomplice, and says, subclause 1 says, with a view to obtaining the evidence of any person supposed to have been directly or indirectly concerned in or privy to an offence to which this section applies, the Chief Judicial Magistrate or a Metropolitan Magistrate at any stage of the investigation, inquiring into, or the trial of the offence, and the Magistrate of the first class inquiring into or trying the offence at any stage of the inquiry or the trial may tender a pardon to such person on a condition of his making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offence and to every other person concerned, whether as a principal or abettor in the commission thereof. So, when Chief Judicial Magistrate, when Metropolitan Magistrate, and when Judicial Magistrate first class can tender a pardon, is dealt as far as section 306 is concerned. And it says this section applies to any offence triable exclusively by the Court of Session. So, which are the offences for which this provision is applicable? If the offence is exclusively triable by the Court of Session, for which you will have to refer to last vertical column of the first schedule of the Criminal Procedure Code. Secondly, or by the Court of Special Judge appointed under the Criminal Law Amendment Act of 1952. Now this is, you have to, refresh your memory and find out. Now this special judge as per Criminal Law Amendment Act of 1952 came into force because of the Prevention of Corruption Act of 1947. Now this enactment has been repealed because of the Prevention of Corruption Act, and hence now you have to go by the new provision, but this is applicable as far as the special judge which is appointed as far as the Prevention of Corruption Act is concerned. It also says any offence punishable with imprisonment which may extend to 7 years or with more severe sentence. So if the offence is such where the punishment does not extend to 7 years, but if it is less than 7 years, this provision regarding tender of pardon is not at all. Any offence punishable with imprisonment which may extend to 7 years or with more severe sentence. So this is, the provision where the provision regarding tender of pardon is made applicable as far as Criminal Procedure Code is concerned. With this now, subclause 3 says, every magistrate who tenders a pardon under subsection 1, what he will do? He shall record his reasons for so doing. B. Whether the tender was or was not accepted by the person to whom it was made, and shall, on application made by the accused, furnish him with a copy of such record free of cost. Subclause 4 says, where any person accepting a tender of pardon made under subsection 1 shall be examined as a witness in a court of the magistrate taking cognizance of the offence and in the subsequent trial, if any. Subclause B, shall, unless he is already on bail, be detained in custody until the determination of the trial. Subclause 5, where a person has accepted a tender of pardon made under subsection 1 and has been examined under subsection 4, the magistrate taking cognizance of the offence shall, without making any further inquiry in the case, commit it for trial to the Court of Session if the offence is triable exclusively by the court, or if the magistrate taking cognizance is the Chief Judicial Magistrate, or to a Court of Special Judge appointed under the Criminal Law Amendment Act of 1952 if the offence is triable exclusively by that court. Now you have to, as I told you, instead of reading Criminal Law Amendment Act of 1958, you have to go by the Prevention of Corruption Act. In any other case, make over the case to the Chief Judicial Magistrate, who shall try the case himself. Now, section 307 along with this deals with tender of pardon, power to direct tender of pardon. It says, at any time after the commitment of the case but before the judgment is passed, the court to which the commitment is made may, with a view to obtaining at trial the evidence of any person supposed to have been directly or indirectly concerned in or privy to any such offence, tender a pardon on the same condition to such person. With this now, the rest of the part, namely last section 308, deals with trial of person not complying with conditions of pardon. And subclause 1 says, where in regard to a person who has accepted a tender of pardon made under section 306 or section 307, the public prosecutor certifies that in his opinion such person has either willfully concealing anything essential or by giving false evidence not complied with the condition on which the tender was made. Such person may be tried for the offence in respect of which the pardon was so tendered, or for any other offence of which he appears to have been guilty in connection with the same matter, and also for the offence of giving false evidence, provided that such person shall not be tried jointly with any of the other accused. Provided further that such person shall not be tried for the offence of giving false evidence except with the sanction of the High Court, and nothing contained in section 195 or section 340 shall apply to that offence. Subclause 2 says, any statement made by such person accepting tender of pardon and recorded by magistrate under section 164 or by a court under subsection 4 of section 306 may be given in evidence against him as such trial. Subclause 3, at such trial, the accused shall be entitled to plead that he has complied with the condition upon which such tender was made, in which case it shall be for the prosecution to prove the condition has not been complied with. Subclause 4 says, at such trial, the court shall, if it is the court of session, before the charge is read out and explained to the accused, or if it is the court of magistrate before evidence of the witnesses for the prosecution is taken, ask the accused whether he pleads that he has complied with the condition on which the tender of pardon was made. Subclause 5 says, if the accused does so plead, the court shall record the plea and proceed with the trial, and it shall, before passing judgment in a case, find whether or not the accused has complied with the conditions of the pardon, and if it finds that he has so complied, it shall, notwithstanding anything contained in this court, pass judgment of acquittal. So that is as far as tender of pardon is concerned, for which we have to refer to section 306, section 307 and section 308 of the Criminal Procedure Code. With this now, section 320, as far as this chapter is concerned, deals with compounding of offences. And then if you read subclause 1, it says, the offences punishable under the sections of the Indian Penal Code specified in the first two columns of the table next following may be compounded by the persons mentioned in the third column of that table. And then after subclause 1, you come across a table which has 3 vertical columns. The first vertical column makes mention of the name of the offence. The second vertical column makes mention of the section of the Indian Penal Code which is applicable, and the third vertical column makes mention as to person by whom offence may be compounded, as far as subclause 1 of section 320 of the Criminal Procedure Code is concerned. Subclause 2 says, the offences punishable under the sections of the Indian Penal Code specified in the first 2 columns of the table next following may, with the permission of the court before which any prosecution for such offence is pending, be compounded by the person mentioned in the third column of that table. So here also you come across a table, and here these offences may be compounded with the permission of the court. So these are serious offences as compared to, if you have a comparison as far as the table which is given as far as after subclause 1 and subclause 2 is concerned. Here permission of the court is required for the purpose of composition of an offence as far as subclause 2 is concerned. With this now, when you read subclause 3, it says that when an offence is compoundable under this section, the abatement of such offence, or that is, for that you have to refer to abatement is not an offence but abatement of an offence which is made punishable, and hence you have to refresh your memory right from section 107 up to 120 of the Criminal Procedure Code. Or an attempt to commit such offence, when you dealt regarding stages as far as commission of an offence is concerned: intention, preparation, attempt and commission. And if you cross the stage of the preparation and enter the stage of what is known as an attempt, attempt is also an offence which is made punishable. And if there is no express provision which lays down punishment for attempt to commit an offence which is also an offence, you always refer to last section, namely 511 of the Indian Penal Code, to know the quantum of the punishment that can be inflicted by the court of law for the purpose of attempt to commit an offence. So subclause 3 says, when an offence is compoundable under this section, the abatement of such offence, or an attempt to commit such offence when such attempt itself is an offence, or where the accused is liable under section 34 or section 149 of the Indian Penal Code, may be compounded in the like manner. Section 34 deals with what do you mean by criminal intent, common intention, whereas section 149 deals with as far as the common object is concerned. Now section 4, if you read subclause 4, small a says, when the person who would otherwise be competent to compound an offence under this section is under the age of 18 years, or is an idiot or a lunatic, or any person competent to contract on his behalf, may, with the permission of the court, compound such offence. Small b says, when the person who would otherwise be competent to compound an offence under this section is dead, the legal representative as defined in the Code of Civil Procedure of such person may, with the consent of the court, compound such offence. Subclause 5 says, when the accused has been committed for trial, or when he has been convicted and an appeal is pending, no composition for the offence shall be allowed without the leave of the court to which he is committed, or as the case may be, before which the appeal is to be heard. Subclause 6 says, a high court or a court of session acting in the exercise of its power of revision under section 401 may allow any person to compound any offence which such person is competent to compound under this section. Subclause 7 says, no offence shall be compounded if the accused is, by reason of previous conviction, liable either to enhanced punishment or to a punishment of different kind for such offence. And subclause 8, very important, deals with the principle, namely it says, the composition of an offence under this section shall have the effect of an acquittal of the accused with whom the offence has been compounded. And lastly it says, no offence shall be compounded except as provided by this section. So this is regarding what do you mean by compoundable, what do you mean by compoundable with the permission of the court, and what do you mean by non-compoundable, for which you have to refer to section 320 of the Criminal Procedure Code. With this, some more sections or the chapters with which we intend to come to the end as far as Criminal Procedure Code is concerned, with which we will continue our discussion as far as next part of our series of lectures is concerned.